All right, this is Thompson v. Clark. I'm going to try to pull out the main arguments from this case. However, Supreme Court cases are very nuanced, and so if you'd like a more thorough understanding of the opinion, I will link it in the description below, and you can read it yourself. So, a brief outline of this video, I will discuss the statute involved in this case, the story, the rules, the issue, the holding, and then the analysis by the majority and the analysis by the dissent. So to get right into it, the statute involved is 42 U.S. Code Section 1983, and this was a statute that was enacted back in 1871, and it's a kind of federal tort liability for individuals to sue state and local officers for deprivation of constitutional rights. And the plaintiff here brought suit for damages under this statute, asserting that officers maliciously prosecuted him without probable cause, and he was seized as a result in violation of his Fourth Amendment rights. One element that must be proved in a malicious prosecution action is a favorable termination requirement, where the termination of the prior criminal proceeding is in favor of the accused. So obviously there's two halves here, a termination that must be favorable. The termination requirement is there because judges want finality and consistency in their rulings. So you can imagine somebody succeeding in a tort action after having been convicted in the underlying criminal prosecution. So there would be one event that occurred, but two different outcomes in the courts. And that's something that the system would like to avoid. And the favorable requirement is there because malicious prosecution claims require probable cause. And if there's an unfavorable termination, that is thought to be conclusive of probable cause, and a malicious prosecution action couldn't be brought forth in the first place. So there must be this favorable termination requirement in order to bring a malicious prosecution claim, and that's the whole crux of this case, because there's disagreement as to what that actually means. The district court ruled that there's no favorable termination because it did not end in a way that affirmatively indicated his innocence. The Court of Appeals affirmed. And so there's a circuit court split here on this favorable termination requirement. Some circuits believe that the favorable termination requires some affirmative indication of innocence, whereas others believe that favorable termination occurs so long as the criminal prosecution ends without a conviction. So the Supreme Court is going to resolve this circuit court split here, and they held in a 6-3 vote that to demonstrate a favorable termination, a plaintiff need only show that his prosecution ended without a conviction. Justice Kavanaugh delivered the opinion of the court. His analysis began by looking to analogous tort law as of 1871, when the statute was enacted. And as of 1871, the favorable termination element of a malicious prosecution claim was satisfied so long as the prosecution ended without a conviction, and it didn't require an affirmative indication of innocence. So Justice Kavanaugh is looking to the past at the time when the statute was written to try to figure out what the intent of the drafters of the statute was. Secondly, an individual's ability to seek redress for a wrongful prosecution cannot reasonably turn on the fortuity of whether the prosecutor or court happened to explain why the charges were dismissed. So prosecutors are not required to explain why they dismissed charges, and it doesn't make sense that somebody would get damages or not get damages based on the decision of a prosecutor on whether to explain or not explain why charges are dismissed. Third, to require an affirmative indication of innocence would be a paradox. And he gives an example here. If the government had a weak case that was dismissed without explanation before trial, one could not bring this malicious prosecution claim. But if government had strong enough evidence to proceed to trial, then one could make a malicious prosecution claim. So it doesn't make sense, because you would think that if there's not lots of evidence by the government, you would be able to bring the malicious prosecution claim. But there's this kind of paradox here that doesn't make sense if the court requires an affirmative indication of innocence. Fourth, officers still have protections from unwarranted civil suits. So this opinion is not going to cause a bunch of civil suits to occur because officers are protected by the fact that plaintiffs still have to show an absence of probable cause and because of qualified immunity. So those are the four main points of the majority. The dissent was written by Justice Alito. with whom Justice Thomas and Justice Gorsuch joined. They began by saying that the Fourth Amendment and the malicious prosecution have almost nothing in common, and they criticized the majority for trying to find commonalities between the two that they say do not exist. An unreasonable seizure claim may be shown without proving any of the elements of a common law malicious prosecution claim. And so they kind of break it up and they look at the elements of unreasonable seizure and malicious prosecution and show that they don't really mix at all. For example, unreasonable seizure doesn't require proof of a prosecution, it doesn't require malice. And then on the other hand, malicious prosecution doesn't require a seizure, and there's no requirement that there's a proof of a seizure without probable cause either. Secondly, the court's recognition of a Fourth Amendment malicious prosecution claim has no basis in precedents. So they look to a couple of cases that the majority depends on and says that it doesn't give weight to their argument. Lastly, the majority's opinion will cause confusion in the future, mainly because the interpretation of the tort requires both a seizure and a prosecution, which don't necessarily have to be together. You can there could be a suit for a seizure and then a suit for prosecution separately, but there's no kind of logical connection between the two. And secondly, the majority says the essence of the claim is wrongful initiation of charges without probable cause, and it's unclear whether this requires a guilty mental state or nothing more than an absence of probable cause. So there's going to be some confusion for law enforcement there in the future. And the dissent would have held that a malicious prosecution claim may not be brought under the Fourth Amendment. So that's the case. I'll post a link to the opinion below and to the oral arguments. And I will see you in the next case. Thanks.